Honorable Justice Shri Jagan, Mr. Rajendra Nair, other colleagues in the panel, and distinguished delegates. I was asked to speak initially by the organizers to speak in the inaugural session. I thought about it and I declined because I have very little understanding about arbitration and the arbitration process, the arbitration law, and the status of arbitration institution in India today. I thought it is better to speak in the valedictory session so that I can gather some points from the presenters, experts who address the technical sessions, and the organizers have conceded to that. However, I have read closely the terms of reference to the expert committee constituted by the Government of India. There are about 12 or 13 terms of reference. I could identify from them or group them together into 6 main terms of reference. After all, the object of this workshop was to gather the views and suggestions of people who are in the field and feed it back to the Sri Krishna committee so that we may have a legislative policy which is informed with the ground realities and the difficulties in organizing arbitration or India as a hub for international arbitration. So what are those 6 major terms of reference to which we need to respond? First, identify the amendments to the laws for encouraging international commercial arbitration. Amendments to the law and the rules. Second, suggestion for institutionalization of the mechanism of arbitration mechanism, the institutional arrangements. Third, an action plan for speedier arbitration, how to expedite it. I put these 3 things together because they related to law and institutions. And many of the suggestions that we have had in the presentations, both in the forenoon session and the afternoon session, are specifically directed to amendments to the law, what new laws or provisions are required, what rules need to be adopted in order to expedite arbitration and help institutionalize it for making it a hub. But the remaining 3 are important from my point of view. What are they? What are the requisite steps for augmenting the skill sets and professionalization of the manpower, human resources that go into making arbitration as an effective mechanism? I think that the government has understood that you may change the law and make it as perfect as possible. You may introduce new institutions and help institutionalize it by supporting structures. But neither of these 2 are going to deliver the justice that is desired. The inadequacies in the law and the imperfections in the institutional mechanisms can be overcome to some extent if the people who are managing those institutions are of the right type. Therefore, the remaining 3 terms of references are important. Number 1, the skill sets and the professionalization. Number 2, how to make arbitration more widely available in curricula and study materials. Number 3, suggest a roadmap for strengthening research and development impacting in this domain. These 3 are relating to what we talked about, change of mindsets, the qualifications to be an arbitrator, the discipline that need to be followed by an arbitrator, the continuing education he or she requires, the research and development that must go in support of institutional improvements. All these are the major 3 terms of reference on which I should think our recommendation will be Can you prepare a curriculum for training arbitrators in the Indian context? Don't adopt the curriculum that is followed in England or America. It will not work. You have to develop a curriculum that is appropriate. You know what a curriculum means. It talks about the objects. It talks about the content, the syllabus, the course content, the study materials, the method of delivery, pedagogy, how to experience, experiential learning, clinical methods. In other words, the Government of India's terms of reference, and I hope there is adequate academic expertise in Sri Krishna committee to appreciate these 3 terms of reference rather than concentrating on amendments to arbitration law, which is not going to make any difference. I can assure you. After all, about 15 years ago, the Civil Procedure Code was amended, introducing arbitration, mediation, conciliation, negotiated settlement as alternative forms in ordinary civil litigation. What has happened? The Bar Council called for a strike, and for a few years, nothing has happened. And even today, rules are being made, but neither the judges nor the lawyers are interested in anything other than adjudication. Therefore, changing the law in this country will not make any difference so long as the lawyers and judges are with a certain mindset which thinks that justice can emerge only through adversarial adjudication, which to my mind can be reserved for certain type of complex litigation, but the rest should be non-adversarial. In fact, efforts have been made in several legislations to abandon adversarial type of truth fact-finding. What has happened to Family Courts Act? What has happened to several labor legislations? You find, or the Gram Nyayalaya Act, nothing will work in this country because lawyers are trained for adversarial litigation only. You have the plaint, the petition, everything will be denied in the written statement and goes on and on and on. Interim orders, appeal, second appeal, reviews, revisions, curative orders, I don't know. Where is the end to it? 3 crore cases, and nearly half of India's population are nowhere in the judicial system. The whole system that is sustained by public money caters only to 1/3 of India's population. I say with some empirical evidence. 2/3 of India's people do not have access to justice. They must depend on Kap Panchayat or some other method which will is a shame to the legal profession, which is supposed to be the largest in the world. Therefore, what is now being talked about of mediation and arbitration are the only hope. Make it as good or even better than what is available through Supreme Court and High Court. Then only you will succeed. So my submission, ladies and gentlemen, if the terms of reference have to be given the weightage that the government seems to give, half of it is on human resources. And I am glad that much of these presentations today focused on that. For example, Samir Shah has repeatedly emphasized mindset. Mindset of whom? Mindset of the arbitrators. More importantly, mindset of the present day judges. Can you change the mindset of 20,000 judges of this country from the Munsif's Court to the Supreme Court? Can you change the mindset of 13 lakh lawyers of this country? And can you get the right mindset for the future arbitrators, the arbitration practitioners, the litigant public who want to go to arbitration instead of going to litigation? It's a formidable problem. I take the blame myself. None of the law schools, and we have about 1,400 law schools in this country, none of them train arbitrators or mediators. They train litigators. How to continue litigation is what we train for. So the amendment to the Civil Procedure Code and the Criminal Procedure Code, Chapter 21A on plea bargaining, have not changed the curriculum of LLB. Because the Bar Council of India's mindset is only litigation. So therefore, the other things will not find a place in legal education. So you want an alternative LLB program which produces mediators and arbitrators only, not litigators. It has to be, because this training which you may give to lawyers and judges will not help them to change their mindset, even if it is 1 week, 2 weeks, 6 months. But a 5-year training for young people to take a career full-time on mediation or arbitration will make a big difference. So therefore, we need to influence and tell this Sri Krishna committee that, look, if at least half of the present litigation should be settled without trial, you must produce full-time licensed mediators, a separate bar council for arbitrators, a separate bar council for mediators, parallel. But in the legislative process, don't make it part of the court system. This must remain in the private domain. That is very important. But the state will naturally have to legislate to put the parameters under which the institutional arrangement will work for imparting justice through mediation or arbitration. Well, therefore, ladies and gentlemen, to put the thing shortly, in few points, first is, of course, the mindset change. How do we do it? There are many suggestions which have been, but I strongly suggest that we must prepare a total curriculum for an LLB program which mainly train, not that you don't tell them anything about litigation, do tell them, but train them as mediators and arbitrators. Mr. Rajendran Nair made a reference that he has been doing mediation and arbitration. Every educated Indian has been doing mediation, arbitration, and lawyers litigation also. It may be in our domestic affairs, in our cultural or various other aspects, we do settle disputes. And this is partly mediation, partly arbitration, etc. But the adjudicatory system has so been ingrained and is institutionalized by the Bar Council of India ever since the Advocates Act was amended. And everything is looked through the prism of the adjudicatory process. And therefore, there are lawyers who publicly speak that this is second-class justice, which comes from Lok Adalat, which comes from mediation, which comes from arbitration. Therefore, after arbitration, take the award to first-class justice, which is there in court. That is the mindset of seniors in this country. So therefore, we are against a very formidable challenge of mindset. Of mindset change. Is that not easy? But it will change if you give weightage to a 5-year program of arbitrators training. Right from the higher secondary school. Yes, if 5 years a child of 17 years is given to me, I will make an arbitrator or a mediator out of him. It's not, he may even do litigation if it becomes necessary. Well, if we can produce transaction lawyers who never go to court, but work in a lawyer's firm and do mergers, acquisitions, this, that, and the other, then why not mediators and arbitrators who do not go to court, but do the same dispute settlement in a manner that is more efficient, more speedier, and more less expensive? My second problem involved is this question of training, empanelment, and accreditation, together with study materials, curriculum, and things like that. I was involved in a legislation drafting in the Ministry of Higher Education in the UPA-2 government, wherein we have this problem of assessing higher education institutions, universities, IITs, IIMs, etc. The UPA-2 government thought about an assessment and accreditation authority of India. And they do not do any assessment or accreditation. What they do is, under certain parameters, they give franchises to competent professional bodies who can make an assessment of different institutions, their courses, their management structures, their ranking in higher education in terms of academic excellence. I suppose a similar framework, legislative framework, could be adopted for accreditation or licensing both of institutions as well as arbitrators. That means the authority is not doing the accreditation work, but competent bodies who are in the field, not necessarily in India. It can be the UK, CIArb. If that is considered to be a professional body making accreditation of arbitrators, let them license. This will be under the legislation passed by India. This is the model which is available, but that legislation could never get through Parliament because of various other reasons. But that legislation is there, which is already introduced in the Rajya Sabha. So I believe that this is one model which you can think about in institutionalizing arbitration, because it will remain in private hands. And while it remains in private hands, it certainly has to follow certain principles of justice, which is part of the constitutional scheme and guarantees. And in order to do that, you can evolve the criteria as to how an institution could be accredited for purpose of arbitration purpose, how an arbitrator could be licensed, what sort of qualifications are required for that, can all be determined by this body, not necessarily by the government, but a body that is approved by the government under the statute. So that is one model I would like to recommend. I would certainly like to recommend that legal education, LLB, we have already started in some places, some optional courses on arbitration, coupled with along some other subjects. There are different types of casual treatment, and that will not make an arbitrator. And that is all bookish knowledge of some information as to what the arbitration is about, how it is different from that. But experiential learning of arbitration can now be introduced in some of the law schools which have some of the best resources. It commands national law schools, some private law schools. They have best of resources. And they can certainly organize if the profession is going to give the attention it deserves to arbitration as an institution. The judiciary is going to give the due status that arbitration deserves in our dispute resolution system. Then naturally the law schools will be able to prepare through experiential learning. During the law school period itself, appropriate, qualified people. I believe it is very well mentioned, I heard from Mr. Lalit Basin himself, that this need not be confined to the legal profession. It shall not be. It has to have a lot of expertise of multiple technologies. Every other professional can be an arbitrator. But in order to make him an arbitrator, he must know as to how it is related to justice delivery. How it is related to justice delivery and what are the minimal standards that need to be kept in mind. He must understand the arbitration law also. In other words, a multidisciplinary approach to institutionalization of arbitration is very, very essential. And in order to do that, not only the curriculum should carry that, but continuing legal education, as it is mentioned, which is what I am doing at present in the M.K. Nambiar Academy for Continuing Education in Kochi. So this continuing education, as he rightly said, lawyers do not need, because they think that they will get continuing education by arguing cases. How do you get continuing education in energy law, competition law, intellectual property law? By arguing cases? You have not studied it. You have not argued any case in that. You need to be taught, or you need to be trained. To some extent, you may be able to acquire by self-study. But can you acquire by self-study cyber law, cyber forensics? I don't believe so, however eminent you be. A lawyer will not be able to do that. In other words, institutionalized continuing education is a must in a technology-driven, globalizing legal environment where competitive excellence is the only way, particularly in the context if you want trade in legal services, where Indian legal profession has to have its share of the turnover. Therefore, ladies and gentlemen, it seems to me that the whole concept of legal education must change to justice education. It's not education about law, it's education about justice. And if you were to understand that, then you know we are all justice workers, not advocates. A hired gun for a client. Very sad state of affairs. If you want to be justice providers, you have a social responsibility. Every case that you argue, even for a private client, there is a public interest dimension, which has to be related to the constitutional goals. Why did the Constitution in its preamble say justice qualified by social, economic, political? Does it make any sense to you? Justice has to be informed, and it is of three varieties: social, economic, political. You cannot make an argument that is not bringing about economic equality, social equality, various aspects of socio-economic development of the country. A lawyer in a private litigation is involved in, even if it is a family dispute, marriage dispute. This public interest dimension is not appreciated by the lawyers who are litigating on commercial disputes, etc. With the result, if you read the Novartis judgment of the Supreme Court, you will understand what I am talking about. The TRIPS agreement or the patent regime will not come in the way if affordable medicines are not available to Indian citizens. The government of India is not helpless. That is where it is written in bold letters in the Novartis judgment, which I'm just telling you about this judgment because in an international seminar in Delhi, soon after the Novartis judgment, when media reported that Novartis judgment will go to WTO, India will not have investment and all pharma companies will run away from here, all that sort of media reports were there. Some African delegates who came to attend that international seminar, I just quote the words of that lady from Uganda or somewhere in Africa. She said, the Indian Supreme Court is God, G-O-D, to us in Africa. This is what she said. Please appreciate a foreigner telling about the judgment of the Supreme Court which highlighted the need for available, affordable medicine to be made available. Patent law or no law, TRIPS or no TRIPS. This is the essence of the constitutional guarantee. Lawyers must realize increasingly and participate. And ladies and gentlemen, therefore, I must only conclude. I have a train to take. I would only conclude by saying that can we change legal education to justice education? Can we structure different models of legal education for providing alternative justice to this vast humanity of 125 crores of people, half of whom are still outside the formal justice system? Please remember that the Indian Constitution recognizes not only the system of justice that you have in the civil court, criminal court, Supreme Court, High Court, no, nor even in the tribunals, but the Schedule 6 of the Indian Constitution recognizes the indigenous informal systems of justice which tribal people in India have. It is untouched by your civil procedure code, criminal procedure code evidence. Even murder trial can be tried through the tribal systems of justice in the northeastern part of India. So informal dispute resolution is constitutionally recognized. Is also recognized under the UN Charter as well. Those informal system is what is sustaining the justice delivery in India today, not the Supreme Court and the High Court and the other courts. That is catering to those who can afford to buy that justice. But the real system of justice is provided by informal systems which are being followed. Maybe that they need to be constitutionalized by bringing in the due process guarantees, principles of natural justice. That is happening slowly. We have to quicken that process and allow those systems also to continue. Otherwise, the courts will collapse. If the rest, two-thirds of the other population also come for their rights to the court, what will happen? Everything will collapse. So it is the informal systems of justice in India which sustains rule of law in this country. Let us recognize that. Thank you very much. I must finally congratulate what I wanted to give. Now a word of congratulation to Mr. Shine Vijayan, Johnson Gomez, Saroja teacher, so many others who have worked hard and have made this national workshop a very good beginning. Congratulations to you. I understand that they are going to have a pro bono wing in this international center. Keep it up so that there will be credibility and public support for your institution. All the best.